You're driving home late at night, blue lights flash behind you, your heart starts pounding, not because you were speeding, but because you remember there's a gun sitting in your glove box, or maybe tucked under the seat. Is that legal? Can the officer take it? Can they search the rest of your car just because they spotted it? And if they do take your firearm, do you ever get it back? Most gun owners have no idea what actually happens in this exact moment, and that gap in knowledge has landed people in handcuffs, in court, and in some cases, permanently without their weapon. Before we get into what the law actually says, hit subscribe and tap that notification bell because we're breaking down real cases and real rulings that every gun owner driving around with a firearm in their vehicle needs to understand. And this channel covers exactly this kind of thing every week. So let's start with the moment itself. An officer walks up to your window during a routine stop, maybe for a broken taillight, maybe for rolling through a stop sign, and their eyes catch the glint of metal on your passenger seat or the outline of a case in your back seat. What happens next isn't random. It's shaped by decades of court decisions that give officers specific, limited power the second they see that firearm. And here's the first thing most people get wrong. Seeing a gun does not automatically mean you've done something illegal. In the vast majority of states, owning a firearm and having it in your car is completely legal, whether it's in a holster, a case, or just sitting in plain view. But legality of the weapon and what the officer is now allowed to do are two very different things, and that's where this gets interesting. Under long-standing Supreme Court precedent, once an officer has lawfully stopped your vehicle, they're allowed to take steps to protect their own safety for the rest of that stop. This goes back to a case called Pennsylvania versus Mims, which gave officers the right to order a driver out of the car during a stop purely as a safety measure. Courts have built on that logic ever since. In a case called Arizona versus Johnson, the Supreme Court made clear that officers don't need any reason to suspect criminal activity in order to take reasonable precautions against an armed occupant. They just need a legitimate reason for the stop to begin with. So the question becomes, what counts as a reasonable precaution when there's a gun in plain sight? This is where state courts have weighed in with some pretty eye-opening rulings. In Pennsylvania, for example, a court upheld an officer's decision to physically remove a firearm from a vehicle the moment he saw it in plain view, even though the driver was calm, wasn't reaching for it, and hadn't done anything threatening. The court's reasoning was simple and a little unsettling if you didn't know this already. The mere presence of an accessible firearm creates enough risk that an officer is allowed to secure it, temporarily take control of it during the stop. Notice what that means. You don't have to move toward the gun. You don't have to say anything suspicious. You don't have to give the officer any reason to think you're dangerous. The gun being there and being reachable is, by itself, enough justification in the eyes of many courts. Now, here's where people get confused and where a lot of dangerous misinformation floats around online. Taking control of a firearm for officer safety during a stop is not the same thing as searching your entire vehicle. Those are two separate legal actions with two separate standards. An officer securing a visible gun is acting under an officer safety exception. But if that same officer wants to search your trunk, your glove box, or containers in your car looking for more, they generally need something more, like probable cause that a crime is being committed, your consent, or specific circumstances like an arrest that trigger a broader search. So can they just see a gun and tear your whole car apart? In most situations, no. But can they walk up, take that visible weapon out of your reach for the duration of the stop, check if it's stolen, run its serial number, and question you about it? In most states, yes, and that surprises a lot of people who assumed a legally owned gun in their car was completely off limits to police interaction. So what actually determines whether things escalate from there? A few things matter enormously, and this is the part gun owners really need to internalize. First, whether you have a valid permit or license to carry, if your state requires one, and whether you can produce it. Second, how you behave in that moment, because sudden movements toward a firearm, even innocent ones, can escalate a routine stop into something far more serious in the officer's mind. Third, whether the gun turns out to be stolen, unregistered where registration is required, or connected to any other unresolved legal issue, because that's often the trigger that turns a plain view firearm situation into a full vehicle search with probable cause. And fourth, and this one catches people off guard, some states have very specific rules about how a firearm must be stored or transported, loaded versus unloaded, accessible versus secured in a locked container, and violating those storage rules alone can justify further police action, even if the gun itself is completely legal to own. Let's talk about what you should actually do if this happens to you, because knowing the law is only half the equation. If an officer approaches and you know there's a firearm in the vehicle, the safest move across nearly every state is to tell them immediately, before they ask, in a calm and clear voice, and to keep your hands visible the entire time. Do not reach toward the weapon, even to point it out. Let the officer direct how the interaction proceeds. If you have a carry permit, let them know where it is before you reach for your wallet or glove box to retrieve it, because officers are trained to watch hand movements closely once a firearm is in play, and a sudden reach can be misread in a split second with serious consequences. This isn't about giving up your rights, it's about controlling the one variable you actually have power over in that moment, which is how the interaction unfolds physically. And here's a question worth sitting with for a second. If the officer does take temporary control of your firearm during the stop, are you getting it back? In most cases where nothing illegal turns up, yes, the gun is returned to you at the end of the stop or made available for pickup afterward. But the process varies wildly by department and by state, and there are documented cases of firearms being logged into evidence, held for weeks, and owners having to navigate bureaucratic processes just to reclaim a weapon they never should have lost access to in the first place. That's a whole other conversation, and honestly, it's one worth exploring in a future video if enough of you want to see it. At the end of the day, the law in this area isn't as simple as you're either fine or you're in trouble. It's a layered set of rules built around officer safety, state-specific storage and carry requirements, and the specific facts of what happens in those first 60 seconds of a traffic stop. If you carry a firearm in your vehicle, understanding these rules isn't optional information. It's the difference between a stop that ends in 5 minutes and one that turns into a legal nightmare. If this broke down something you didn't fully understand before, let me know in the comments what state you're in, because the rules genuinely shift from place to place, and drop a comment on what legal topic you want covered next. Subscribe if you haven't already, because we're covering exactly these kinds of situations every single week, and I'll see you in the next one.